Assalamualaikum and welcome to J News. I am Nur Amira Ibrahim and I will be your host for today. So, without further ado, I would like to share one important topic. Drum roll please. Yes, the drawback of Dworkin and the right thesis. The background theory of law is the nature of legal agreement lies in the best moral interpretation of existing social practice. His theory of justice is that all political judgment ought to rest ultimately upon the injunction that people are equal as human beings. In brief, it means that legal reasoning is an exercise in constructive interpretation. Dworkin's right thesis involves the general claim that within legal practice and a proper understanding of the nature of law, rights are more fundamental than rules. If there is any right come into conflict with any policy, the right must prevail. To Dworkin, different judges may come to different conclusion, but he insists that the judges may not rely on their own political views, but only on their belief on the soundness of those convictions. That's all for me, and let's give it up to Balkis.
Thank you, Amira. Now into the first and second criticism of Dworkin right thesis theory. The first criticism of the Dworkin right thesis theory is that Dworkin never laid down the ways to apply this legal principle. According to this theory, a judge may resort to the legal principle instead of legal rule when he is faced with a hard case. A hard case is a case whereby a judge cannot find the answer or solution based on the legal rule. So, according to this theory, a judge has the option to choose the legal principle over the legal rule in this instant case. However, he never laid down as to how this legal principle should be applied. What are some requirements that need to be fulfilled? Because as we all know, absolute freedom may lead to abuse. Apart from that, he also did not provide as to what extent this legal principle can be used to solve the case. Hence, it can be seen that Dworkin had failed in explaining in depth of his theory. The second criticism is that there are more than one correct answer. There was a critique towards the right thesis theory by Dworkin whereby he said that different judges would have different judgment as different people have different views and opinions. By this, how can one know which one is the correct answer? It is a general custom that there is no right and wrong answer in the legal field. It all depends on the facts of the case. For instance, there usually would be a dissenting judgment in a case where few judges had a different view and thus deliver a different judgment or verdict. However, one cannot say that this dissenting judgment was wrong. It may be correct or it may be wrong depending on the circumstances of the case and how one argued his point. So here, Dworkin is wrong that there is always one correct answer in solving a case or legal issue. Now, I'm going to pass the stage to my friend Suhaila.
Thank you, Balkis, for the information. Hello everyone, this is Suhaila 264678, and right now I'll be sharing with you guys another drawbacks about the Dworkins and the right thesis. So one of it is that the denial of the discretion of the judges is incorrect and of course will cause confusion on the common conceptions of the judicial responsibility for opinions. Yes, the judges has the discretionary power, but it doesn't mean that they can do whatever they want. In fact, they have to exercise their power within the confines of the constraints of judgment. Believe it or not, there are few examples that are actually contradicting with the right thesis stories. For instances, before granting the claimant's right in a matter of nuisance, the judge may examine the impact of his discretionary power on the community, and such instances shows that the courts are actually considering the individual's right while make the decisions of the policy. And that's all from me. Let's continue our video today with our beloved friend Nilas.
Much obliged, Suhaila. Your Honor, I am Nila Masari, appear before the court. Today, the prosecution submit that, according to Dworkin, there is a relationship between principle and the rule of recognition. McCormick tries to demonstrate the relationship according to him. Rules can be explained as based on principle. For instance, traffic rules can be explained as based on principle of safety, principle of speedy and free of movement of traffic. However, the drawback is that in most cases, it is indirect relationship. In Malaysia, to take one example of law, is Road Transport Act 1987, where it clearly stipulated that it is an act to make provision for the regulation of motor vehicle and of traffic on roads and other matters with respect to roads and vehicle thereon. Ideally, all motorists, regardless of types of vehicles, must be cautious, disciplined, and abide by the law, and to be considerate of other road users, motorists, and the public in general. Therefore, I rest my case and pass the floor to my learned counsel, Anis. Much obliged.
Thank you so much, Nilam, for the great information. Hi, my name is Anis Kimlia binti Yusami. So today, we are here at the library and search for cases that related to Dworkin and the right thesis. Let's go! Riggs against Palmer. The fact of this case is where Elmer murdered his grandfather so that he might receive his will. The issue arose in this case was whether a murderer could inherit from his victim. In the lack of any other laws, the court in the US opted to adopt the legal concept that no one should profit from their wrongdoings. Therefore, the killer was refused the inheritance. Imagine if the court took the positivist position that all laws are lawful under the former test, the court would almost certainly rule in Elmer's favor. Hence, according to Dworkin, where an existing rule was plainly going to result in the wrong response, the court employed a principle to arrive at the correct answer. Dworkin emphasized that there is always one correct decision. Thus, it is up to the judge to apply his judgment when deciding whether or not rules should be imposed, altered, improved, or abolished. Alright, I think that's one of the cases that we can relate to. So maybe I can see you guys around next time. Thank you so much for having me today. Bye-bye!
Thank you, Anis. To sum up, Dworkin's work has consistently been concerned with judicial interpretation of law and the role of judges. Dworkin is clear as to the political value he is committed to. This is what law is for the people we want to be and the community we aim to have. Thank you.